Despite the dreams of many folk, the reality is the moment you try to live off-grid, build something simple or stay permanently on your own land, an entirely different system appears. Planning law, enforcement notices, visibility, complaints. Owning the land often turns out to be the easy part. If you can buy land but still can't legally live on it, how much freedom do ownership rights actually give you? Living on the road, waterways or off-grid in the UK. Dickie Dread. This is part 9 in the video series, and we're still on chapter 1, types of travellers and off-grid folk. And today we're going to talk about off-grid land dwellers and smallholders. So, living on land outside the conventional housing system is often seen as the most stable form of alternative living. Unlike life on the road or the water, it offers the possibility of staying in one place, building something, growing food, establishing a long-term base. But that apparent stability comes with its own set of constraints. Land may be owned, but its use is tightly controlled. Off-grid land dwellers and smallholders form a diverse group. Some are attempting to create low-impact homes, living simply with minimal reliance on main services. Others are working small plots for subsistence or income, combining elements of agriculture, craft and self-build. Some come from travelling backgrounds and are seeking a more settled version of the same values. Others arrive from conventional housing looking for autonomy, affordability or a different relationship with land. Despite these differences, they quickly encounter a common reality. Ownership does not equal permission. Buying land does not automatically grant you the right to live on it. The moment land is used for residential purposes, it enters the realm of planning law. And it's a fucking nightmare, trust me. This is where many expectations collide with legal reality. A piece of land may appear unused or neglected, yet still be subject to strict controls. Temporary structures, caravans, cabins or self-build homes may seem low impact, but if they're used as a main residence, they can trigger enforcement. What matters is not how the structure looks, but how the land is being used. In this respect, land-based living shares more with road and water-based lifestyles than might first appear. On the road, the issue is where you can stop. On the water, it's where you can moor. On land, it's whether you can remain at all. In each case, the underlying question is the same. Who has the authority to decide how space is used? Planning systems are designed around the assumption of fixed, authorised dwellings. Anything outside that model tends to be treated as an exception requiring justification. This places off-grid land dwellers in a difficult position. The more permanent and established a site becomes, the more visible it is. More likely it is to attract attention from planning authorities. At the same time, there are long-standing tensions within the system. Some forms of rural or low-impact living have gained limited recognition, particularly where they can be framed as sustainable or tied to land-based work. In practice, however, gaining permission is often complex, uncertain, highly dependent on local policy and interpretation, and we're going to say a hell of a lot more about this in chapter 3. I think it's chapter 3, not chapter 2 or chapter 3, but next chapter. As with other forms of alternative living, a significant number of people operate in grey areas. Some rely on temporary permissions, some on low visibility, and others on the slow passage of time in the hope of establishing lawful use. Outcomes vary widely. What is tolerated in one area may be challenged in another. Culturally, off-grid land dwellers sit at an intersection. Some identify strongly with travelling traditions, carrying forward ideas of self-reliance, informality and independence. Others see themselves as small-scale rural residents or pioneers of sustainable living. In practice, these distinctions matter less than the shared experience of negotiating a system that was not designed with them in mind. Living on land offers a possibility of rootedness, but not freedom from regulation. Like the road and water, it is space where autonomy exists only within the limits defined by law. There's a bloody... I'm not sure if it's a wasp or a bee in here. I'm hoping it's a bee. It's putting me off. Right, off-grid land living. Key legal points, and we will cover all of these in much more detail later on, so this is just a summary for now. Owning land does not automatically grant the right to live on it. And yeah, it is chapter 2, this will be covered, and I really will go into a lot of depth and say how you can get around things, etc. The key legal framework is planning law. That's covered by the Town and Country Planning Act 1990 and associated regulations and local planning policy. What's called material change of use occurs when land is used for residential purposes, and this normally requires planning permission. Living in a caravan or mobile structure on land is still considered development if it forms a residential use and it is not genuinely... Oh, it is a B, I don't care. It's not genuinely incidental or temporary. The legal definition of a caravan is set out in the Caravan Sites and Control Development Act 1960 and the Caravan Sites Act 1968, and I will go into that in Chapter 2. Even if a structure qualifies as a caravan, planning permission for residential use may still be required. Enforcement action may include planning contravention notice, what's called a PCN, enforcement notices, and stop notice or temporary stop notice. Failure to comply can lead to fines, court action, and removal of structures. Time limits can apply in some cases. The 10-year rule for change of use to residential, which comes under the Town and Country Planning Act 1990, and the 4-year rule applies in more limited circumstances, for example, operational development. It is not simply that 10 applies to caravans and 4 to houses. That is not what it is, and we will really go into depth about that in the next chapter. Agricultural land has additional restrictions. Residential use is not automatically permitted, and agricultural occupancy conditions may apply. Low impact or off-grid living has no automatic exemption. Planning permission is still required unless specifically granted. In practice, enforcement varies widely between local authorities. Some situations exist in long-term tolerated grey areas, and formal permission is rare but possible in specific cases. So the legal basis is primarily derived from the Town and Country Planning Act 1990, the Caravan Sites and Control Development Act 1960, and the Caravan Sites Act 1968, and associated planning enforcement legislation and policy. Living off-grid is not simply about escaping modern life. It's about negotiating a system built around fixed, authorised ways of living. The issue isn't just caravans, cabins or planning permission. It's that modern society often assumes there is only one acceptable model of living, permanent housing inside a tightly regulated framework, which means the real conflict may not be about land at all. It might actually be about who is allowed to live outside the standard economic system. And if that's the case, what happens to people who no longer fit the model society that was built around? Next up, we'll go back to the horse-drawn travellers and we'll cover the legal side of horse-drawn life.